I think 4 different assistant attorneys general and 4 subjects. We were in the uncomfortable position of believing that had we allowed them to disclose this, that the next thing we'd be dealing with was a complaint to the IRS. In any event, there are 2 other items on here. The legal bills, and I've already told you that we offered to redact, and Mr. Jones is the one, and this is his only request, who said he didn't want that. So in our view, that count even shouldn't even be here, because had he agreed to take a redacted version of legal bills, he would have gotten it. And then on number 6, this count, in our view, should also be dismissed on the basis that the request was made by Mr. Videen. The district responded that it would get back to him after they sent the request to me. I was out of town. I came back into town, and the lawsuit was filed. The district never had the opportunity to affirmatively respond to Mr. Videen before the lawsuit was filed.
Why is that required? In other words,
well,
you're back now. Why haven't you simply said, okay, here are the documents, or those documents cannot be provided for this legal reason?
As to the, well, we have a reasonable opportunity to respond. And by the time I got back into town, I found out about the lawsuit because someone had seen counsel's press release on it. And then we got the complaint. And this count, this request, was for something I had not had a chance to get back to the district on, and we had not affirmatively or negatively responded to the plaintiff at all.
And it's unclear to the court what your response will be.
No.
Other than we're kind of tired of responding, so we're not going to anymore. Is there any legal basis? Or
we have no problem giving him these documents. We just never got a chance to give it to him. And then we tried to open a dialogue with them about going through the documents and seeing if we could come to a meeting of minds of what they would get. I don't have any problem giving him these documents. We got sued before we had a chance. I had a chance to go back to the district and tell them to give the documents. And at that point, we got into the paper mill.
Okay.
As to the counterclaim, the counterclaim arises from the same conduct, that is, this 100-plus requests of Mr. Videen and other matters. We think we properly pled it. I think you could. There's an argument that it's a compulsory counterclaim, in that the conduct of the district and the conduct of the plaintiff are intertwined in this factual situation. But be that as it may, we think that it is appropriately pled, and that we ought to be able to get a reply from the plaintiffs and pursue it. We don't see that. I mean, there's no urgency in this matter. The documents that have been identified that are subject to this lawsuit exist. They're not going anywhere. And we think that some further discussion, we've filed a joint application you may have seen, showed our willingness to mediate this. And we think that that's an appropriate resolution of this if it's possible. But in any event, we believe that we have raised defenses and questions that need to be resolved, and that action at this time, would be premature.